You're live.
Are they on? Good evening, good afternoon. This is the Joint Committee on Judicial Retention. The committee consists of Senators Ruth Hardy, Dick McCormick, Brian Collmore, and Mark Golick, and Representatives Angela Arsenault, William Knott, Thomas Oliver, and Joseph Chip Troyano. And we are meeting on the 22nd of February to consider the retention of the Honorable Justin Giron, Gregory Rainville, and Kristen Schoonover. Schoonover or Schoonover?
Kirsten Schoonover.
Sorry. I have a niece spelled the same way, and she pronounces it Kirsten, so I apologize. I just want to make a couple of remarks, if I may. First of all, I would ask that the committee, after we're done with the judges, if the committee would stay for a few minutes. I want to just talk about committee business. Oh, by the way, I also should mention our staff. We have Peggy Delaney, and we have Eric Fitz. Sorry, I know that. Fitz-Williams. And I want to say that there is an interesting pattern that we've noticed over many judges, which is that the comments tend to be pretty positive. Almost no one gets away without some negative comments. And if you start doing statistical analysis, you find that sometimes it's two people who said something. And if the other comments are overwhelmingly positive, one is reluctant to really hammer somebody. However, judges have tremendous power, and we want to do our due diligence. And somebody had some negative thoughts about the judge. So we have an obligation to look into everything. It has the unfortunate effect of a judge coming to us with a pile of positive comments, and the conversation is mainly about the one or two negative ones. And I apologize for that. But that's really what we have to look into. Let's see. I guess those are my comments. I have to swear in anyone who is likely to be giving testimony. Please raise your right hand. Do you solemnly swear or affirm that the testimony you are about to give shall be the truth, the whole truth, and nothing but the truth, subject to the pains and penalties of perjury?
I do. I swear.
And we begin this evening with Judge Justin Giron.
Thank you. Good evening. I am Justin Giron, and thank you for the opportunity to meet with me and let me talk to you about my request for retention. I was appointed to the bench last January, and after the orientation process began presiding in Caledonia and Essex County in February. But before I was appointed as a judge, I was a prosecutor in Chittenden County for 19 years. And before that, I had about 3 to 4 years in private practice in New York, as well as a short time in Essex, Vermont. My caseload currently is the entire adult criminal docket in both Caledonia and Essex County, as well as the family division. I have the divorce and parentage custody cases in both counties and the mental health cases. I spend most of my caseload as criminal, so most of my time is doing that. And most of my time geographically is spent in Caledonia County, with about 3 to 4 days up in Guildhall in Essex County. This is obviously my first experience with retention, and I am appreciative of being able to do this early in my career. At first, my thought was, I'm not sure what to make of the process after a short time, but the more I thought about it, the more I realized that if I could come back in a year versus coming back in 7 years or 6 years, I think this is a good time to do it, because it gives me a chance to see anything that I can improve on, any areas that need to be flagged, concerns that people may have about me. So I'd rather do it now than wait too long. The downside, of course, is that I'm in a smaller county or a smaller jurisdiction. I don't have exposure to a great deal of attorneys. So I think the survey responses are a little bit limited. And I'm told from my colleagues that after being rotated to another county, I'll probably have I can expect to get a lot more responses back, as I've had a chance to see more attorneys appear in front of me. But I did find, I looked through the survey data. I looked at it with some apprehension and anticipation. And I thought, on the whole, it was pretty encouraging. I say that because when I'm looking at just the data, not looking at the comments necessarily, most of the comments that I received or most of the ratings I received were in the very good or excellent categories for the various questions. And I thought that to me was encouraging after a fairly short time on the bench. I note that there were 18 attorneys who had provided responses, and of them, there were 6 provided comments, 3 of which were positive, 3 which were negative. And so I focused on the negative ones, as was mentioned. The first one was a comment about 2 particular cases. They identified 2 cases in particular. That same person indicated they had an impression that I had a bias against female attorneys and the prosecution. Second comment was that they felt I struggled with probable cause and conditions of release. They also felt that there were several months spent to get an evidentiary ruling returned. And then they also had a comment about bias, indicating they believed I was biased against putative victims as well, especially females. And then the third comment was somewhat reverse, and it said that they thought I appeared to be biased in favor of a female litigant. And then they also had a comment that I should have some training on unconscious bias toward female litigants in family cases. So it appeared to me that was a family, probably from the family court. They felt that was a concern generally amongst the judiciary. Obviously, well, maybe not so obviously, but my primary concern were the comments about bias, because I think everyone understands how important it is that the courts be a place that's free of bias as much as possible. People will not have confidence in the judicial system if they think that they can't be treated fairly, whether they're depending on their race, gender, sexual identity, whatever it may be. So when I saw that there were comments about concerns that I might be biased against females or in favor of females, that was something that jumped out at me, and I thought that's something I need to take special care to look at. A couple ways to do that. One is, of course, self-reflection, which is sort of an ongoing process. You have to do that all the time. I've been through bias training in both after being appointed to the bench, but also when I was with the state's attorney's office in Burlington. And what struck me at the time was how difficult it is to identify your own bias. If you go through the they do various exercises that you can undergo, and you realize quickly how the biases come out, even when you think of yourself as someone who's not biased. So the self-reflection is something that you have to keep doing over and over again, and you have to do it. I know I have to do it going forward, and I can't just rest and think that I'm fine. The other thing I understand too is that bias is very difficult to recognize in yourself. It's something that I think other people may pick up on when we try to examine it for ourselves. We may think we can spot it. It's, I think, much more difficult than we really understand. So one of the ways that I'm hoping to address these concerns, in addition to just being more self-aware, which I hope to be. The other thing, though, is that we've got Judge Zone has begun a program, or there's a program starting for new judges, not just ones up for retention, but to have a mentor with a retired judge who will be observing us when we're in court online. So it'll be unannounced. We won't know that they're there. We won't know who they are. And after that, we'll have an opportunity to, and this will happen more than once. It's not just a one-time thing. We'll have a chance to sit with that judge and get their impressions, get their feedback about how we're doing or how we're not doing. Judge Teachout will be my mentor, Mary Teachout. So I'm excited about that because obviously Judge Teachout is female. So my hope is that maybe better than having me teamed up with a male judge, because again, we don't know about our biases. So if I can have someone with a female's perspective observing me and how I interact with everybody in the courtroom, I think that'll be beneficial to me. The other thing is, of course, that Judge Teachout, although I admire her and I've met her, I don't really have a relationship with her. So I don't think she'll have any concerns about protecting my feelings. We're not really friends. I think I'll get honest feedback from her, and I think that'll be helpful for me in the long run. And in addition, I know that she's got a great deal of experience, obviously, very wise, and I'm hopeful that she can, not just looking at my any issues of bias, but generally looking at me as a judge, looking at my rulings, looking at my the way I approach a case, all that sort of thing, even though it may only be limited to the courtroom, but I'm hoping to expand upon that when we have a chance to meet. The other area that I was concerned about was the comments about the conditions of release and probable cause. As you know, I've been a prosecutor for many years, so I'm very familiar with probable cause and conditions of release. That was a big part of my job. I do have, I think I may have a different approach to conditions of release from my background in Chittenden County compared to the what may have been the prevailing views in Caledonia County, Essex County. And my view is that I have to follow the law. The law is, I think, pretty clear that we're bound to impose the least restrictive conditions that we can for any particular case, but we have to look at each case individually. So it's important that I guard against giving a blanket response just because a case is of a certain variety. It's important that I look at the case and look at the individual and the circumstances. And I have to make sure that I'm explaining my decisions to the litigants, to the defendant, to the state, so that they all understand exactly why I'm doing what I'm doing and not just, here's my decision and you may not like it, but that's what it is. And I do take time to, when people ask for conditions, I'll consider them and then I'll make sure both sides have had a chance to explain their part. And then I'll decide, here's the conditions and here's why I'm making these conditions. And I think it's just important I continue to do that so that people understand exactly why I'm doing it. But I also think I have to be true to the law and what I believe is the actual appropriate conditions for a given case. Same is true for probable cause. Probable cause is a low bar for any particular charge, but I think it's important that every case has evidence to support all the essential elements. It's not difficult to do, but different people have differing opinions on what a case is. So two judges could decide differently on what probable cause is for a particular case. And again, it's important that when I make a decision, I explain it. And one thing that I haven't done thoroughly in the past is really to do that. Typically what I've done is indicate on the information, the state's information, no probable cause, and maybe a word or two. What I think I'll do in the future is try to be a bit more explanatory so there's no question for the state's attorney as to why I'm making that decision. And I will say that the state is always offered the opportunity to respond at the arraignment if they want to make any statement. And sometimes, once at least they have filed a motion to ask me to reconsider. So I think there's a way to get around, to address any concerns they have about my rulings on probable cause. Again, though, I think that will be helpful to me to have Judge Teachout watching me do arraignments and getting a sense of what I'm doing and giving me her feedback on how she would do it or another way to possibly do it. There was a concern about the late evidentiary decision, and that really is a valid concern. I do have one particular case where I had taken a hearing and I had written a decision shortly afterwards, within a couple of days, because it wasn't a very difficult decision to make. But unfortunately, in the Odyssey system, I don't know what I did, but I did not send it to the clerk to issue. And so the case continued. It was at least 3 months later that we were in for a status conference and the parties asked me about the decision. And I was really surprised. I'd forgotten. I remembered the case and I said, I really thought I did that decision. So I said, I'll get that out as soon as possible. And I went and looked and the clerk looked and there it was sitting in Odyssey. So we got it out the same day and with an apology to the parties. So I don't know if that was a particular concern that was addressed in that comment, but I do recognize that the parties are entitled to having decisions issued promptly as possible. I have recognized that that's an area in my part that I need to improve upon because you've heard before from other judges, I think, that difficulty in finding time to write decisions is a challenge. And for myself, I think being new, it is a particular challenge, especially with the family docket, which I'm not that familiar with. But the way to get around that, I think, or the way to address it is for me to ensure that I have the findings time I need. And the clerks, the staff, I think are pretty good about that. They automatically will give findings time to me. I have on occasion asked for additional time, and I think I need to make sure I'm not holding back when I need to do that, especially if typically the docket's pretty full. There's not much time. If we have trial days and a trial doesn't go or it doesn't get picked, that's an available day that I like to grab onto for findings time. And the clerks like to take it and put in more hearings. So we have to negotiate sometimes as to how that day is going to get used up. But I think it's the priority really has to be to get these decisions out so that people aren't waiting for a lengthy period of time to get the case, or especially if it's a dispositive motion that may have been, if it can get the case moving along quicker, I want to make sure I get that out. The other, in terms of comments, there was an additional comment from staff, which was, I think, probably the one that was jumped out at me most. It was, they had a number of concerns about my being prepared for hearings, which is, I think, a fair statement in the sense that I can see the perspective because, for instance, today I had a full docket of relief from abuse hearings. There were about 13 cases on in a 3-hour period, which is more than they would normally put on, and it may have just been an oversight. Ideally, any judge would want to read everything that they can in each case in advance of the hearing so they have a better sense of what to expect and what the arguments are going to be. Relief from abuse hearings are not generally, the issues are usually pretty much the same. But even so, that's a lot to read. And even if you have a chance to read everything, once you get into court and you're doing hearing after hearing, it's very easy to get, one may look much like the other. And so I can see from looking at if someone's looking at me from the outside, if there's, if I'm fumbling, if I'm not sure about which case we're working on, it's certainly going to appear that I haven't been prepared. I think that I prepare pretty well. I do take time to read everything. And for every case when people come in front of me, I take the time to explain why we're there. I'll explain if I've seen if they've filed pleadings, I'll say, I see that the state has provided this or the plaintiff's provided this, defense has done this. I understand these are the issues, let me know if I'm not on track, if there's something else that I'm missing. So I do that because I want to make sure that the parties understand that I have looked at their case, because I think it helps them to know that I take the case, it's important. But it also gives them a chance to correct me if I have missed something, because there are a lot of pleadings that get filed. If I didn't catch what the pertinent one was, I want to make sure that they let me know about that before we get going. But again, obviously the staff person who wrote that felt that was a concern, and I don't want to, I'm not going to downplay that. I want to make sure that I do what I can to be more prepared and to appear more prepared. So I will do that, obviously. There was a comment about decorum and presence, courtroom management. Again, Judge Teachout is not the Band-Aid for everything, but I do think that she hopefully she can see how I, appear in court and let me know if am I not keeping proper control, or is there something I should do to do better? I will say I had an experience early on, maybe been about 3 or 4 months after being appointed, 2 attorneys in a family court case, a male and a female. One was on WebEx and one was in person. And the male attorney and it was pretty contentious. They were going back and forth. And the male attorney at one point made a comment, and this is after the female attorney's audio stopped. So she couldn't respond. She couldn't say anything. So I was explaining we'll have to continue the hearing, but I did want to give the attorney who was there a chance to say something. And he did. Unfortunately, he made a rather disparaging remark about the female attorney, and it was a sexist remark. And I didn't say anything at the time. And when the hearing was over, I went back to my chambers. I thought more about it. I was disturbed by it. So I ended up issuing a written decision. And I explained what had happened in the hearing, what the attorney had said. The other attorney had not had a chance to respond, that I thought it was inappropriate and a sexist remark. And I said, just explain that it was not appropriate, would not be tolerated in the future. And I felt that by doing it in writing, it might carry a bit more impact. I mean, I felt I had to address it in any event because it had happened and it wasn't fair. And I wish I had done it at the moment, but I think I was caught off guard. But I also hope that by sending it in a written, because it becomes part of the record, it's there. And it was an attorney who was somewhat, I think, a bit irreverent in other circumstances too. And I thought this might be a chance to sort of correct the behavior, not just in that case, but overall. And so I say that because that's an example, I think, of trying to make sure that there is proper decorum in the courtroom, and that if someone is behaving in a way that's unfair to another gender, that it's the kind of thing that has to be addressed. But I wish I had done it immediately at the time so that it could have been stopped in its tracks. The other thing I would like to say is that there is the ability for judges, I think, to get retention surveys every 3 years instead of every 6 years when they're up for retention. So I'm told that I can do that in halfway to the next retention process. So I think if I can, I certainly will, because I would like to get that feedback rather than later. And after 3 years, I will have rotated to at least one other county, so I'll have a chance to have been exposed to a number of other attorneys and litigants. Finally, I do feel I need to respond to the comment about the two cases that were referenced, Mr. Schuman, Mr. Balch. The concern there was that I'm hesitant to use conditions of release or to hold people in jail if they are a risk to the public. Obviously, I can't use bail as a means to hold someone in jail because they're a risk of harm. I can only do that if they're a risk of flight. And so that is something that's a constant argument back and forth. In this case, though, Mr. Schuman's case, I had actually held him in jail for lack of a responsible adult, which was the complaint that was made in September. And these are just, without getting into the facts or the arguments, these are just part of the record. In October, I was out of state for a training, and another judge did release Mr. Schuman to go to treatment, which is something I probably would have done myself. When I got back in November, Mr. Schuman had been arrested for a new offense and relapsed. And so I, at that time, again, held him in jail for lack of a responsible adult. And he's still there to this day, although 2 days ago, the state and defense did file a motion asking to release him to treatment. So I just want to bring that up because it's not, the way the comment was made, I felt was not the full story. I want to make sure you understood that I don't hesitate to impose conditions that will require someone to stay in jail if it's necessary. But my first thought is, what are the least restrictive conditions necessary? And particularly with someone who's got a very severe substance abuse problem. You know, we don't have a drug court in Caledonia County, and I don't know that we will have one, but the only thing we can really do is do what we can to get people into treatment. And so we have to sort of fashion conditions of release that get them there. It's not the best way to do it. I don't like the idea of the court sort of babysitting defendants. I don't think that's our function. And I don't think it's a function of law enforcement either. I think the best outcome for most folks is to get their cases resolved. And if they need to be on supervision, then they can be on supervision with people who are trained to do that. But while they're in front of me, my goal is to get them into treatment if that's what they need. And that was the case with Mr. Schuman. The other case, Mr. Balch, number of charges against him. In May of last year, I did hold him in jail for lack of approved residence, a curfew violation, a curfew condition, basically. So again, another person who has been held for lack of, because they are constantly reoffending and they can't meet that condition. But what I do when someone is held like that is I get them set on jury draw if I can, as quickly as possible, so they're not staying in jail longer than they have to. Those are the comments I had about the comments that I had looked at, and of course I'm happy to answer any questions that you may have.
There's a bunch of experts in the room on this. I thought, and maybe I'm wrong, I thought the Vermont Constitution was amended in the 90s so that a judge could withhold bail for public safety if the evidence was great.
Yep.
And that the defendant got an immediate appeal.
You can, there's two ways to hold people without bail. The most common is under their statutory, under 13 VSA 7553A, if it's a violent offense, a felony, and they need to be held without bail because there's no conditions that you can impose that will make them make the public safe or the victim safe. And then there's under 7553, if it's a light felony charge, so murder or some of the other felonies, they can also be held without bail. It's a little bit easier to hold them under that section. Under 7553A, if you hold them without bail, they have to be released within 60 days on conditions or bail. You have to set bail or conditions. So they have that 60-day limit. But from the cases that were referenced here, the Mr. Schuman, Mr. Balch, they were not violent felonies. They would not have fit under either of those two exceptions. So the only way to hold them would have been to set bail on them or to impose conditions that they couldn't meet.
No, I was just whispering to you.
Oh, sorry.
No, I wasn't doing that.
As this conversation continues, I should make clear, we understand it is not our function to relitigate. Okay, or we are not an appeals court. So what we are looking for is indications of the judge's competence and temperament. Ruth, would you like to start?
Sure. Thank you, Judge Sharon. It's nice to meet you. I thank you for taking us through all your sort of responses to the comments. There obviously were some comments that were a little concerning, but you've only been a judge for a year. And if you had been a judge for 5 to 10 years, I would be much, much more concerned about those comments. So I really appreciate that you're taking it very seriously and trying to think about, be introspective about the comments that you have. Bless you. Wow.
Thank you.
At the same time. Excuse me. That you're being, thoughtful and really thinking about how you can do better. I'm really happy to hear that Judge Teach Out is your mentor. We retained her, I think, 2 years ago, if I recall. And she's an excellent judge, and I think that she'll be a great help to you. And definitely recommend the 3-year, mini retention thing. It's not really a retention, but the survey. That is also something that we sort of got back started a couple of years ago.
Okay.
Terry is she here? Yeah. Instrumental in making sure that happened. So that's a great tool to use. And I recommend definitely sitting with another judge and going through the comments. I know it's confidential, but don't just keep it to yourself. Have somebody else, even maybe a non-judge. If you want me to come over, I'll
Thank you.
I appreciated, one of the things I appreciated, you didn't talk about it, is the way that you handle self-represented litigants.
Yes.
And you walked through in your letter what you do and how you try to make sure that they understand what's going on and ask them questions and have them repeat back to you if you're not sure. And I really appreciated that approach. This is something that we've heard many times is an issue. So kudos to you for making sure they understand. I would have more for you if you'd been a judge longer. I not to say that I'm giving you a pass or whatever, but I think that you haven't been a judge long enough. It's really a hard job. And a lot of what you were saying about the stress and the backlog and everything, you walked into a really difficult situation to begin with. So I guess my question to you is, do you feel like you have sufficient support to improve as a judge? And do you feel like you are able to do your job well? Because it sounds like, 13 RFAs and in 3 hours is a heck of a lot. And that takes a toll on somebody too. So do you feel like you have the support you need? I know you're saying this in front of your bosses, but just ignore them.
I'll look the other way.
I do, and thank you for your comments. What I was really impressed about, and I had heard this from other judges who had, before I was put my name in and before I was appointed, that it's a very considerate group of people who are always willing to help out and respond to requests for assistance, and that's been a huge thing because I come from a criminal background, which I'm pretty familiar with and pretty comfortable with. Family court, not so much.
Whole new ball game.
It's a whole new ball game. And so I've had a lot of questions and people have always been very quick to respond and respond quickly. So if I have a question, I can usually get a response back within 10 minutes, 15 minutes. They're that quick. And it was actually Judge Zone who had pointed out to me, I need to make sure that I get my findings time and not to let anyone push back on that. If I need the time, I need the time, and that's just the way it's going to be. So I really do feel I've got that support. Part of it is me being more willing, if I need to sort of say I do need more time. It's tough because I don't want to see cases pile up and people need their hearings. But the reality is, if I just fill my days up with hearings, which is easy to do, there's just never time to get things done other than at night or on weekends. And I can only do so much. My wife will tolerate a little, but not, complete workaholism. So, but to answer the question, yes, I do think I have the support. Thank you.
Okay.
Yeah.
Great. So what I would expect from you then is that in 6 years or 3 years when you're doing your middle, we don't have comments like these, and that you're able to improve in the areas that you have identified and that your commenters have identified, and that, you're confident and efficient and kind judge and all the other good words. And if you're not getting the support you need, just speak up and make sure you get it so that you can meet that expectation.
Thank you. Thank you. My goal too.
Yeah.
I address Senator Hardy as Ruth.
That's all right.
Formality.
That is my name.
I generally address colleagues by their full title over dinner. And in the State House where we work together, it's first names.
Martine?
Yeah, Martine.
Thank you. I don't know a lot about courtroom decorum, but I did notice that one of the comments talked or mentioned within a glowing reference, talked about you arriving or allowing folks to arrive late and have food and drink. And I was just, it made me think, do you have just a relaxed style about you? You seem relaxed and sort of gentle. And is that a style choice, or is that something that when you read, you thought, oh, I got to tighten that up?
It's it may be a combination. I think I am a fairly relaxed person. My courtroom demeanor is fairly formal, but low key. I'm quiet. I don't get my voice doesn't get raised. I don't tend to. I try not to show much emotion. That's advice I was given. But I also don't think it's very loose necessarily. What we still have a combination of video as well as live hearings, and I've encouraged people to appear remotely if they want to or if it helps them, particularly the litigants who may have work commitments or other things. And there are people on the WebEx who are often much more relaxed, and so I've had to stop people from smoking on a couple occasions. People, I think, I have seen them drinking and probably eating. I don't really remember the eating, but it wouldn't surprise me if that was happening. The courtroom, though, I really don't see that happening. There was one hearing a couple months ago. I'd had a closed hearing at lunchtime over the lunch hour with a prosecutor and a police officer. And so she missed lunch. And so she and I had court immediately afterwards, and she actually did bring in a snack. And that may be what the person was commenting about, because I didn't stop it, and I knew she had missed lunch, and she was very discreet about it. Other than that, I don't. I think I try to make sure that the courtroom is, it's contained. There's not a lot of. There's no shouting. There's no goofing off. There's no joking around back and forth. But I will pay more attention to anything about, especially food and drink, because that is people can have water, but they shouldn't be drinking their coffee, and they shouldn't be bringing in their snacks from outside. And I think the way to do that for me is just I don't want to embarrass people. I think I'll quietly talk to the court officer and say, could you just remind so-and-so that they can't be bringing their food in?
Thank you. Yeah, and that the hybrid model is challenging no matter what I have found.
Yes.
So thank you.
Thank you.
Representative Oliver.
Hi, Evan.
Hi.
You covered Schumann pretty well, and that's where I was going to go. So I'll ask you another question.
Sure.
So you're very new to the judgeship. We all understand. And where do you see yourself at the end of your career? What are your goals and aspirations? Don't say retired.
My goals, if I could pick how I would look in whenever I do retire or at the end of my career, I would like to, I'd like to be a confident judge. I'd like to be someone who's comfortable in his own skin, who can rule from the bench much more often. That's something I have not been doing as much. And I know that that's something that can really help my workload, and it can help the cases move and help the litigants. I hope that people, whenever I do reach the end of my career, will have a picture of me as someone who's thorough, who's reasoned, who's above all fair, and that they felt comfortable being in front of, whether they were to win or lose, whatever that case may have been or whatever the arguments may have been. That's what I'd like. I would like not to have, a lot of folks saying, boy, that guy, I'm glad he's gone. So, rather they're saying, I wish he'd stuck around a couple more years. Sure.
Moving on.
Excuse me. I'm all set. Thank you.
Thank you.
Representative Arsenault.
Thank you, and thank you. You sort of addressed this already, but I'm curious to know, since so much of your time in the state's attorney's office was in Chittenden County, and you're now in Caledonia and Essex, we know those to be two very different parts of the state in many ways, quite similar in others, I'm sure. But it made me wonder, and of course, understanding this is your first, first experience, first judge placement, it made me wonder what your approach might be or how your approach might change, if at all, depending on where you are located, where the court in which you're presiding is located, if at all.
Well, it's a good question. I'm not sure how it would change. I don't like the idea of changing necessarily the way I approach the law or certain situations. So that's why I think there's been some, I don't want to say conflict, but I think that my approach to, like, as I said, condition to release is not what may have been the experience for folks in the past. So I think what I want to avoid, though, and I knew this when I was appointed, I want to avoid coming in and being the person that says, this is the way we're going to do things. I want to change the culture. I want to change the way you do things. And I don't want to do that. What I do want to make sure people understand is, here's how I feel, but I want to work with all the parties who are involved, the state as well as the defense. And so that we're mutually respectful and we understand where we're coming from, even if we can't agree. But I don't want to come across with the impression that they think, well, here comes Judge Dyer, he's trying to change everything we're doing. And that's not the impression I want to give. It just may be that I have a different view and that's going to have some effect on them probably, but I don't want to tell them they should resolve their cases a certain way. That's not my function. And I've avoided getting into many conversations. I've invited conversations with some of the attorneys. I say, if you'd like some feedback, if you're for a particular difficult case, I'm not going to insert myself, but if you want, I'm available if they say they can't resolve something. But I understand completely that they see me coming with a background as a prosecutor. Prosecutors don't always like other prosecutors telling them how they should do things, and I don't want to be doing that in either Caledonia or Essex County for sure. So my approach, I think, really is to, for instance, if I get rotated to another county, to pay really close attention to what it feels like there before I come out with any sort of changes to the way things are done. And one of the best ways to do that is having a bench bar meeting, which most judges do when they're rotating to a new county. I've done that twice in Caledonia, where I meet with the defense and the state and talk about whatever issues. And it's much more informal, a chance for them to feel free about making comments about what I'm doing, and I can ask them why they're doing, what they're doing. I probably would do that more quickly when I rotate next time. When I did it in Caledonia, it was a couple months, because I was still kind of getting used to everything. But I think it's helpful to do that. And frankly, probably more than just a couple times. I think it's helpful to do it every few months.
Thank you.
Sure.
Senator Cowell.
Thank you, Senator McCormick. So I appreciate that you focused on, as I think a lot of us have read the comments, but I'm a little bit confused by what Senator McCormick said at the beginning. So I'm going to ask the question that I want to ask, I guess. I've been able to see multiple news stories in the newspaper up in your county, which have been very critical, to be fair, about the situation where folks come before you and are released or don't have to post bail. And I'm a non-lawyer, so I'm really trying to grasp the idea and the situation in terms of procedure, whether public safety can be taken into account when you make a decision about whether to hold somebody or ask them to post bail, or whether that really has no impact on things, and that your really only concern is whether they will reappear. If, in other words, if you don't impose bail or conditions, that you won't see that person again. Mm-hmm. So if you could just sort of walk me through it as someone that, I'm at the mercy of the reporter who wrote the story, and it seems like, wow, how could that happen? Yeah. But maybe I don't understand what's going on.
No, thank you. That's so when a person comes to court for the arraignment, the bail statute and condition to release statute is 7554. It's Title 13, 7554. The presumption is that a person is released on their own recognizance without any conditions. And then the court has to, only if there is some sort of risk of flight, the court can consider some conditions. And if there are not sufficient conditions to ensure they'll come back to court, then the court can impose bail. And for misdemeanors, it's limited to $200. But that's only for risk of flight. So there's no discussion about their risk to the public. If there's a risk to the public, the court can impose additional conditions of release. And if they're of a certain felony, the court can impose a responsible adult condition. And that's the one that usually gets people held because the responsible adult has to be to the court's satisfaction. So it gives the court all the power to decide whether I'm going to release them to this person. If I don't think that person's sufficient, then they're just going to be sitting in jail. But again, that's limited to certain felonies. So misdemeanors, I think maybe domestic assault, but there are certain categories of cases that are qualified for that. And then you can impose other conditions that you think are reasonable. For instance, that curfew condition that I mentioned, saying they have to be an approved residence. But in order to have them held without bail, or to impose, but to get back, I think, to your question originally, you just can't impose bail just because there's any risk to the public. And that's a pretty well-defined rule that if they're a risk of not coming back to court, yes, you can. But if it's a risk of public safety, then you have to have some other reason to hold them. And it's either that they are committed to violent felonies, so someone's shooting, aggravated domestic assault, things like that would fit. Then you can hold them without bail if you decide that there are no conditions that would satisfactorily protect the public. So I still have to do that analysis. And I think what a lot of folks don't, and I understand the public sees someone commits a crime, they come into court and then they're out again. I think a lot of people who see that are mixing their desire for punishment for the crime as opposed to the adequate conditions to get them back to court and protect the public. And it's natural because people want to see someone pay for the crime that they commit. And that may be more important in some counties than others. It's just a struggle. And I'll confess that I tend not to read the paper. I've seen headlines on occasion, and I've had people mention something about the paper, and I've really said, I just can't look because I can't be swayed by public opinion. I have to focus on what the law is, and it may mean that there's a lot of shots taken, but I hope that people recognize that the newspaper is, gets only a limited amount of information. So
I've always wondered whether judges did. I know if you're a professional athlete and you're taken to task in the newspaper, they always say I never read, but yeah, I think it sort of gets back to them in one fashion or another.
You do hear things.
Yeah. So I think it is a misperception on behalf of most of the people in Vermont that what you've just explained doesn't allow you by statute to take public safety into consideration. I didn't know that before I spoke to another person whose opinion I really respect and learned that. So I did want to get it on the record here in case there are people listening or will read this later that say, well, you did answer the question, and I appreciate that.
Thank you.
I do want to second Senator Hardy's sort of hope that further training and experience, there's nothing like experience. The more you do what you do, the better you get at it, or I guess you stop doing it after a while. But, so I'm hoping, and I think that mentor program is an excellent idea. I really do. And I think Judge Teachout will be a very, very good mentor for you. So as Senator Hardy said, in 6 years, we probably won't get the same comments that we got this time. And I wish you the best.
I'm counting on it. Thank you.
Representative Troiano.
So, Senator Cullimore, you should have been in our committee room when Judge Zone went over that exact same scenario today to explain to our committee about conditions of release and bail. So it is a little tricky, and the Caledonia record is not always correct.
I wasn't sticking up for the reporter.
I know, I'm just kidding. So, Judge, welcome, and it's good to see you here again. And a few of the things that you commented, I thought it was really very sincere of you to take every single comment to heart and to talk to us about it. And that's really a great thing, because you as a judge, it's my belief that every attorney who's appointed to the bench wants to do a good job. And it's a really important position. It's appointed, or you're nominated by the governor, and you're supported by the entire Senate. And I think that it is a difficult job, and it's somewhat social isolating, and it just, there's so much baggage that comes along with it. But it is a wonderful position to be in, and it is an esteemed position. And I think one of the things that you bring, you mentioned here tonight, what you bring with you is self-reflection. It's one of the most important things that you said here tonight, because when you read these comments and you take just a moment to step back and say, oh, let me think about this, it's going to make you a better judge. It's going to mean that you can reflect on things, including bias, because this committee examines bias in all the judges we speak with, because it is oftentimes unnoticed, as you say. And again, stepping back and taking a look is very important. And I think, again, Judge Teachout will be a good mentor for you. I spent a lot of hours in the courtroom with Judge Teachout, and she's well-versed, and I think that you'll learn a lot from her. And I think that taking on that tutorial is a very wise idea because the learning curve is about as steep as it is around here when you step through that door the first day of the legislative session. I won't comment on Mr. Schulman or Mr. Bulch because I think we represented both of them. So I'm not going to comment on that. But I do have to say, conditions of release, what you say, what you explained to Senator Callamore is not perceived oftentimes by a large majority of the population. And as someone who has worked on thousands of condition of release cases, I guess I won't comment any further on being lenient or not lenient on that. And you walk a very fine line between treatment and incarceration, and it's really that's another huge consideration that you face as a judge, and to whether or not you can help this person or if they're maybe beyond help right now in their life. So that's a really important piece. And those are just the things I wanted to comment. Again, some of the comments were not particularly fair as I read them. And I think that you took them all to heart. And I think that's the most we can ask of you after 1 year on the bench. And I echo everyone else's sentiment that I'm sure you'll be have accolades in the next 6 years when you return to us.
Thank you.
Anyone else? Any last thoughts? Any last thoughts from you, Judge Jarman?
Just thank you. It's a really interesting experience, and I look forward to seeing you again in the future. Thank you.
Thank you. Sure. Thanks. We'll turn our attention to Judge Gregory Rainville.
Evening.
Good evening.
You folks sick of talking to judges yet?
Not yet.
Not yet. So I wish we had a couple hours to talk because there's an awful lot about this job that I like, and an awful lot of things about this job that's very difficult. So 17 years I've been sitting on a bench, and I never thought I would be here this long. And then COVID came along, and a lot of judges went home early. They were sending us home without work, and I did not like it. And I was surprised. I found out that I like the action, I like being involved, and I did not like the accumulation of cases. I did not like the fact that we couldn't dispense justice and get things done. So that was a major revelation to me. That was a couple of years ago. And I went back to work and I asked the clerks, because my chambers is right near the clerk's office. So I'm in Costello, 6 judges, 3 floors. We get a lot of judges to talk to, which I really like, and I make use of that. I went into the clerk's office and said, anything that comes in, search warrant, emergency pickup order, whatever it is, bring it on down. And they did. And I kept working full time through the whole thing. It's not that I'm a workaholic. I'm not. I work a lot of hours and I work hard like every judge does. But it's a combination of things. There's so much need out there to get the job done. There's so many people who have cases that have to be heard, whether it's juvenile cases or whether it's domestic cases or the criminal cases and people sitting in jail trying to get them to trial, and we're backed up terribly. We're making some progress. It's going to take a long time to catch up. There's a great deal of need, and I found myself mired in that need the first few years that I was on the job. I very seldom left before 7 o'clock at night. I worked every weekend. Came close to burning myself out. If there was a case, if you had findings time, and the clerk would come to me and say, I have this case, it really needs to be heard, I'd say, fine. I'd hear it. I got behind in my findings. I got tired. And when you get tired, you don't make good decisions. I'm an incurable optimist. I like people. I like working with people. I just do. Okay. It's not hard for me to say good morning to people when I walk in the courtroom. I greet attorneys by name. I greet defendants by name. I don't get it right every time. I mess up sometimes, but most of the time, I'm known as a cheery judge. I really am. I like to treat people well, and I don't forget where I came from. I was raised on a dairy farm. Father had an 8th grade education. I don't forget that. And it's important. So, this brings up a good point. There was a woman who made a comment, said she was a young attorney, and I used her badly in court. That cost me half a night's sleep, and it should have. I don't know if she has the right judge, but if I did that, I'd like to be able to apologize to that woman. Not because she's a woman, not because she's an attorney, but because she's a person. I didn't treat her well. I made a pledge to myself that when I took the bench, that I was going to be as fair and as equitable as I could possibly be. And that's what drives me. It's trying to be reasonable, trying to do what's right. And get it done. So over the years, I've learned to be much faster on the bench. I used to be able to handle 50 arraignments in the morning, get through it, sometimes more. I could take changes of pleas. When I was up in Franklin County, we'd bring in 100, 120. This gentleman was there a few times. I mean, one judge, we got 120 people in front of us, and we're trying to process them in a day. It's ridiculous. But you have to be fast. And I learned to be fast without cutting the essential corners. You have to cut some corners, the stuff that's not important, or you're not going to get through it. That's a hard lesson for the young judges to learn. You don't have to dot every I when you write a decision. You got to get the decision out. It's got to make sense. It's got to be well-based. I can do a lot of it from the bench. Occasionally I mess up when I do it from the bench and I get one kicked back to me because I didn't do it well enough. It's not because I had the wrong decision, usually. I've had that too, but not usually. Usually what happens, I didn't document it well enough. And you were talking about bail. I have a couple of, bail is one of my favorite things. I'm known as a bail judge. I set a lot of bail. I hold a lot of people. In Chittenden County, we have some serious problems. We have a lot of violent crime. We have a lot of drugs. We have people coming in from out of state. They establish a temporary residence with somebody. They claim that as their residence. They are shipping fentanyl. They are killing people. I had a case in front of me. This has happened 2 or 3 times in the last few months. Person comes in, no contacts to Vermont, sold a lot of drugs, confidential informants, video surveillance. Evidence is overwhelming. They've been charged with felonies. They were put back on the street, and a few months later, they go back to Springfield or Connecticut, wherever they're going, to load up the trunk. They come back to do the same thing again. Oftentimes, they are treating the people who they move in with badly. They just kind of take over the apartment, or if it's a woman they're living with, oftentimes there's physical abuse going on. They have guns. They have lots of money when they're arrested. I have no compunction about setting heavy bail on a person like that. And in Chittenden County, it's a very different attitude. The violent crimes, yes, they sit on those pretty hard. But the other crimes, they don't. And it's a philosophy. It's an approach. It's not one I agree with. But the state's attorney has their own powers. If they want to dismiss a case, they can dismiss a case to make a plea deal, whether I think it's a good idea or not. So the idea about bail, and about conditions of release and holding people. The Supreme Court has been very definitive that you cannot hold a person without bail or set high bail solely to protect the public. It's frustrating to me. But that's the way the Constitution is written, and that's the way it's being interpreted. However, it can be a component of what we consider. So if there are other factors going on, this person has very few contacts, no job, unstable housing, 6 failures to appear, long record, and we get a lot of those cases. I had a change of plea in front of me today, 13 retail thefts in a year, third of them felonies. A couple of times he attacked the retail people who were trying to stop this person. And he had an ag assault, and they brought it in for a plea agreement, okay? Now, he hadn't been proven guilty of anything yet. And I've been on the bench long enough to know that some of those cases don't stand up. But when I'm looking at 20, 25 cases in a year and a half's time, you can't ignore that either. So the criteria we use, 7554, says look at the crime, look at the ties the person has to the community, look at their ability to make good judgment and good decisions. Do they have a stable job, stable housing? Those are all factors that we take into account. We also can take into account the danger to the public. It just can't be the controlling factor. So it's there, we can use it. And as Judge Jiren pointed out under 7553A analysis, if it's a violent crime, and you see that all the time in relationships, husband and wife, girlfriend, boyfriend, whatever, and one won't let the other one go. They're constantly chasing them down, sometimes choking them, sometimes assaulting them, and it's repetitive over and over again. I mean, you have to treat that very differently than you do the single assault case. All right. The bail stuff could go on forever, so I'm not going to talk for 2 hours. Promise you. I'll shut it down. I'm sure you have questions. So I have sat in Franklin County, Chittenden County, Lamoille County, Orleans County, Caledonia County, Addison County, and Grand Isle County. I count myself lucky that there are 2 or 3 counties that are trying to get me back to sit on their bench. And there were some fairly harsh comments that came from some of the individuals. I think part of that, the ones talking about bias, who said I was biased against poor, biased against people with criminal records. You have to look at criminal records. If we don't, we're not doing our job. And yes, I look at them, but I go through them in front of the defendant with the attorney. If I'm going to set bail or I'm going to hold someone, I go through that piece by piece by piece in front of them. And so if they've got 5 failures to appear or 20 failures to appear, which we see, and they have violation of probation, they have conditions of release over and over they're violating, I'm looking at that, and I don't care if they're poor or rich, they're going to have bail set because they're out there doing stuff constantly, and I'm seeing a stack of cases. Again, they haven't been found guilty of anything yet, but you can't ignore the mounting evidence you have in front of you either. So that's the balance. Now you compare that against someone who does something serious one time. That's a very different matter. Very different matter. But histories, you have to look at the history. It's a great predictor of what people are going to do in the future. It's not always on point. So we bring people in, if they have a serious crime. Lots of times I use a condition for responsible adult. I talk to that person, make sure they're going to really do their job. Some judges don't like conditions of for, which is a responsible adult, but it's a good way to keep someone coming to court when they're supposed to. Stop reoffending constantly. I mean, you see people coming in with 8, 10, 12 cases, just racking up the charges. And there's strong evidence to support it. That's the kind of person you put on a curfew or you put on a condition for a responsible adult situation. So someone's monitoring them and will call the police if they violate their curfews, or they contact people they're not supposed to contact. So, the other thing I wanted to talk about was settlement of cases, especially family law cases, juvenile law cases. There's so many cases in so little time that when I walk into the courtroom and I hear an attorney say, we need a 3-hour merits hearing, my first question is, what are the issues that you're contesting? And I want to know, I'm not just going to pull up 3 hours of time we don't have, set it, and then they show up and it settles in half an hour, which is a great thing if it settles. But now I've got a 2.5 hour block I could have used for something else. So I press. And I got some comments that said, you know, he's got the case figured out, or he's already made up his mind what he's going to do with the case. Well, yes, I read the file and I know what's in there. And so then I start asking the attorneys, you know, give me information. Tell me what it is you're really contesting. What is it you need a time for? Who do you have for a witness? What's your proffer as to what that witness is going to say? Why are they here? And it works. I've settled an enormous number of cases that way. And sometimes just talking to the litigants directly, put them under oath, start asking them questions. If it's a family case or a juvenile case or something like that. I'm taking evidence, but I'm talking to them like this, as opposed to the attorney calling the witness, defendant gets up, then the other attorney gets up. You can burn through an enormous amount of time doing it that way. There are some cases you have to do it that way. There's no other way. Majority of cases you do not. So I spent my whole life litigating cases. That's what I've done my whole life. I understand the beast. I understand what it takes to get to a result and try to get it done. And that's what I enjoy doing. And that's what I miss when I couldn't do it. So I'm sure you have some questions. I'll stop talking for a minute and let you folks ask me questions.
You were described as gruff.
I don't know where that came from.
You are, no, you're.
Honest.
Sure you do. You're a gruff, you are gruff. Guys like me like that. You and I would have a good time together. I think there are people who find it intimidating or challenging.
You know, one of the things that occurred to me is, and I've had people say this to me before, you're very authoritarian. And I don't really mean to be that way, but I'm fairly intense. My voice carries. Fairly sizable guy. And so you put all that together. And so I have to be careful with that.
I once pleaded not guilty to an illegal turn in New York because I had enough, I was 19. I had enough, you know, the high enough score of violations that if I got convicted for the illegal turn, I'd lose my license. So I pleaded not guilty, and you remind me of the judge. Let's go around. Brian, you want Senator Collins?
Thank you, Senator McCormick. So I sit on the Senate Ag Committee, so that resonated with me that you came from dairy farm folks. But I do want to just mention, and Senator McCormick did, that the word grumpiness was in one of the comments, and then there was another one about moods, or maybe being moody. But I can also understand, I think, that you do come across as sort of a no-nonsense type person, maybe. Do you think you're grumpy?
No, I'm not grumpy. Not in the least. I asked a couple of my comms about that, and they, who are they talking about? Because that's not you. If anything, I have to be careful with my sense of humor. So I'm not overdoing it. Sense of humor in the right place, right time really helps. But at the same time, like I said, when I go into the courtroom, I usually say, good morning, how you doing? You know, and try to get things rolling that way. They understand that they have a judge there that's going to run the courtroom, but at the same time, I don't want to do it with an iron fist because that doesn't work either. I will say, I laid awake thinking about this stuff. I really did. It bothered me a lot. Because I don't want to be grumpy and I don't want to be the one who's using people badly. I've seen that happen before, and that's no good. So I did lose my mother-in-law in May, and I did lose my father in September last year. And was helping to take care of my father-in-law when I was up in Newport working, and had a lot of rough nights with him. He's got dementia. And so, yeah, it was a rough year. 21 was a very rough year. So there may well have been days when I came into court, you know, too much caffeine, not enough sleep, get cranked up, big caseload ahead of you. So may well have happened.
I also noted, and I'll just mention again, I think we've heard from the great majority of judges that we've talked to. You mentioned the legislature's oversight and funding to provide internet and cell coverage equally throughout the entire state is the most important contribution necessary at this point. And we've heard a lot of comments about the new Odyssey system, which is different from what we had before, and how you get that spinning circle on a
spinning wheel.
And then literally it's like an assembly line just breaking down, and nobody can do anything until it starts up again. So I'm hoping that we'll be able to.
It takes a huge amount of patience. Someone made a comment that I seem to have a lot of trouble with my computer. I do. Every judge does. I mean, today I was 45 minutes trying to get from my chambers, set up a laptop, docket in chambers, bring up the program, and then we're supposed to be able to go on the bench and conduct a hearing remote. We don't take our laptop with us. Some courts you do. You take your laptop from your chambers into the courtroom. In Costello, you don't have to do that. It's supposed to be quicker, more efficient, and it is generally, but there are times when it just won't connect. And I had half-hour hearings backed up, and it was just, couldn't get the thing to connect. I went and got the IT guy, and he spent 30 minutes on it trying to get it going. There's that. The connectivity issues, WebEx is a wonderful thing. Really is. I mean, we have people from out of state who can testify. We have attorneys who can cover 2 or 3 counties. We don't have enough attorneys in juvenile court. We don't have enough attorneys sometimes in criminal court. So the fact that when I'm sitting up in Newport, I'm up there 2 days a week right now. The fact they can bring in a Chittenden County attorney to represent someone can help move that case forward. On the other hand, there are certain times when you have to have those attorneys in court in front of you. And I'm fairly certain some of the pushback I got was because I've been insistent about that since September. We have 30 to 40% no-shows, arraignments, status conferences, whatever. Things got extremely casual. We talk about people leading on camera. I had a woman in a termination of parental rights hearing, a mother who was testifying, get up and go answer the door. So I asked her not to do that. Turns out it was her landlord, and she was having landlord problems. So 15 minutes later, knock on the door, and she said, "I've got to get that. It's my landlord." And I said, "No, you can't leave. You are in court. You have a lot at stake. Please don't leave." Slam the computer down. Shut me off. That's the most extreme one I've seen. You do get people, confidential hearings, you get people walking through the room behind them. You can hear them being coached by other people. They're sitting there in their pajamas, kind of, it's just, so I met with the other judges in Costello, and COVID had reduced enough so that we could, with reasonable little risk, bring people back into the courtroom. And so we started requiring that people be there for arraignments. Got a lot of pushback from attorneys, a lot of pushback from state's attorneys even. They wanted to work out of their office or work out of their home. Sometimes when they're working out of their home, the connectivity was terrible. We'd lose them. Spending 5-10 minutes on a busy docket trying to get people reconnected. And it's, that's why I said if we get good internet connections, it's just critical. Just critical.
Hopefully we'll find some funding.
Yeah. So that would be a big deal. But I did, people have to be at arraignments because they meet their attorney. They fill out the condition of release form and sign it. They fill out the public defender applications. They weren't doing any of that. It just got so casual that it was it's getting really difficult to get any work done. So we started, saying, look, everybody has to be here for arraignment. Status conferences, do it by WebEx. Evidentiary hearings need you here in the courtroom. We have exhibits, you got to pass them around. It's just too hard to do it through Odyssey, and it takes too much time. Got a lot of pushback on that, but gradually, people, now everybody's back in gear and they understand, and it's not so much of an issue, but it creates some hard feelings.
Thank you.
Representative Arsenal.
Thank you. Hi,
Hi.
it's nice to meet you.
I'm sorry, I didn't catch your name.
Angela Arsenal.
Arsenal, okay.
Struggling with where to start. I guess I'll start with, I believe that words matter a whole lot. And the funny thing about the word judge, as I'm thinking about it, is that we expect judges to make judgments. It's the job. At the same time, I would hope that judges in many ways are quite free from judgment, or at least prejudgment. And I'm in a number of the comments and in hearing you speak to us tonight, I'm worried that you might be making decisions about people before you've heard from them, based on your experience, extensive as it is, and unconscious bias that you may not be aware of. And I worry about how that affects outcomes of cases that are brought before you.
Can I address that for a second?
Sure.
That's a huge point. And I give that impression. I mean, if I've sat down and gone through a file forward and backward, and I think I know the attorneys, I know the parties sometimes. So yes, you do form judgment calls, no doubt about that. I mean, there's no way around it. The question is whether or not I can accept evidence and give it the weight that it should be given. So when I orient jurors, one of the things I say to them is that there are countless times when I look at a case, I hear some evidence, it seems to be going in a certain direction, and then all of a sudden somebody comes in and testifies with credibility and it flips it. And I try really hard to keep that door open and listen for that evidence or listen for that person, because it happens, and it happens frequently enough. So prejudgment, I don't see that as a problem, because if you're doing your job, you're going to have prejudgment. You just are. Anybody who says they don't, they're not reviewing the files. It's not so much about prejudgment as it is being willing to accept and listen to what's being presented to you. And that's why I try to drum into jurors is do not make a final decision about a case until you've heard everybody and everything. So,
Yes, I can understand that distinction somewhat, but I maintain my point.
No, I understand. And it's a fair one.
And I, this, one of the comments that stood out to me, it mentioned he regularly berates those in front of him. That may be a temperament thing, but I don't like reading that, because I think people are coming in often at the lowest or very difficult points.
Absolutely. I think you will find, if you talk to the staff people who work with me every day, that is not what happens regularly. I don't dabble what I've done it. But it often happens in a context where I'm getting an argument that I shouldn't be setting bail for any reason. Judge, there's no reason to be setting bail here. Well, the evidence is just totally contrary to that. And so I'll fire back at them sometimes and say, well, 18 failures to appear, 6 violations of probation. So that's true. I do get into some pretty lively debates with the attorneys sometimes. In order to do their job, they have to be pretty dedicated. And they sometimes will come up with arguments that there's not a lot of facts to support what they're throwing at me. And so that's just hard to listen to, because it's just not there. You can't get your teeth into it. When somebody comes up with something that's good, they can have a long record, but if they're doing something about it, they're going to drug rehab, if they're got alcohol counseling, whatever it is, if they're addressing the problem and there's some chance they're going to change their life, it's a whole different ballgame. Look at that very, very differently.
And my final thought is, again, on my opening theme of that words matter, and maybe as an example of a lack of awareness of how your words might hit other people, I would point to your letter and this one line that stood out to me, your intent, seeking retention, where you say, it helps to remember that when I'm at home, I'm not the judge in my marriage, a most difficult task. And I sense that was intended to be funny. And to me, you're disparaging your spouse.
Okay.
It's sort of like this is the joke told about women.
Yeah, I'm telling a joke on myself, but I can see where it wouldn't come across that way, and I should have rethunked that one. So
I'm just sharing that.
I have a very dynamic wife, and
that's wonderful.
she runs a household.
Dynamic in general, but it is repeating an oft used
Understood.
the way to undermine women.
Understood. So that's one of my big things. I have 7 sisters. I married a woman who worked in the court system, and I convinced her to leave the court system, go back to college, which I spent a lot of time and money and helped raise her 3-year-old to get her through pharmacy college. She's now a pharmacist at UVM. Domestic violence is a big thing with me. I see men controlling women all the time. I can spot that pattern a mile away. Could have seen it 1,000 times, and I've had a lot of training in it. And I probably prejudge those cases. But when I see that controlling behavior, that has to be taken into account and it has to be handled. And it's that concept. I grew up in a very conservative farming community. Women had their role, men had their role. Okay. It doesn't work. It just doesn't work. So I miss a beat sometimes, but there's no greater advocate for women than the guy you're looking at. I think that we have to do a lot more with domestic violence training so that people understand it a whole lot better. So anyway.
Thank you. So my question.
Sorry, you're Mr.
William Knott.
No, okay.
So my questions were involving computers, and you'd answer that partially. But you talked a lot about, and I fully agree. I remember sitting in when they did the court day in Rutland County, and some of the attorneys that were remote, you just couldn't understand what they were saying, and those connectivity issues. So I understand that's something we desperately need to work on and fix. But there's also the question of individuals staying on top of things, and I know just from personal experience, doing that with computers can be frustrating. So I just wondered if you'd like to reflect it all on perhaps how you personally relate to the computer system, if there's room for improvement there.
Oh, sure. I have a flip phone. I do. I do that partly because as a judge, I don't want my life on a phone that gets hacked. I mean, everybody's lives are on those phones, and I don't think that's good for a judge to have that. I do have a work phone that's a smartphone as well. I appreciate technology. We all had to learn the Odyssey system. I learned the Odyssey system. It's a difficult system to work with. Very difficult. It's helped us in a lot of respects. It's slowed us down in a lot of respects. I get a motion to continue. I used to be able to check off granted or denied and sign it. Could probably do that in 10 or 15 seconds, okay? Now it takes me 23 clicks with a mouse just to say yes or no, sign it and date it. The staff in a courtroom have been slowed down enormously. I can't do 50. I can do 50. Arraignments in a half day drive the staff wild. They can't. There's so many clicks and it's so non-intuitive And if someone has 6 or 8 cases and I set conditions and it has to apply across 6 cases, they have to go into 6 individual cases. They can't just, copy it to those. They have to go through and do every single click all over again. So it slowed us down enormously. So I can understand how people get frustrated in court and say, why are things taking so long? Why is this that? We have some wonderful staff. We have some people who are very, very talented and very quick. But, the system needs a lot of improvement.
And we certainly heard some comments, if not complaints, from other judges that we've heard from in this session about the excessive clicking and the separate files and all that. So that's a point that has been made before.
And don't get me wrong, there are some real benefits to the system. There really are. It's just that there's this other side to it. In terms of speed, VTADS we thought was, a dinosaur. VTADS was much faster. So there you go.
All right, thank you. Thanks.
Thank you. Representative Oliver.
Thank you. Good to see you. Obviously, it's fair to say we have a pretty good idea. I've seen you in the courtroom a lot.
A lot.
Yeah, in that manner. So I don't have a lot of questions to ask about that, I guess. But what I would ask is, so having looked at your score sheets and things like that, what are you going to work on personally? What strikes you and you're going to work on in the future?
Well, she pointed out some things that I've been told before, and I forget about sometimes when you get involved in the job. I think the presentation, what words I use, and the way I deliver the message is really, really important. And that's probably the biggest thing that I need to be careful of. So, that's one of the great things about this job. You never stop learning. It's always there. So, and I do appreciate your comments. I really do. I probably don't think so, but I do.
Yeah, that's what we're here for.
Are we moving on? Sound done, okay.
Yeah, sorry.
Thank you, Chair. I will defer to my colleague on my left.
So
you're the one I understand reads the decisions and really looks through what we submit.
yes,
Yes.
and you have been a judge for 17 years, and unlike Judge Gyron, you should have no excuse for the type of comments that you saw in here and for the ratings you got. I was highly disturbed by what I read and what I've just observed with how you've just treated one of my colleagues. It's unacceptable for someone in your position to be so dismissive, to display such a lack of ability to listen, and to show such disrespect. Your cases, the 2 that I read, were not very well written. They were difficult to follow and sloppy. You were dismissive. You were flippant in your file to us. I think my colleague explained one example. You didn't back up your case at all, your case for why you should be retained as a judge.
Understood.
You say that there's nobody who's a better defender of women than you, and there are multiple comments in here about your sexist attitude, and that you seem to, you have a permissive attitude towards many domestic violence cases, and you seem to take a view that it's a private dispute a little too often. You demonstrate a clear bias toward anyone with a criminal history, poor people, people of color, women. I lost sleep over my first appearance before Judge Rainville. He was rude and dismissive and wouldn't let me speak. This judge fails in the most important judicial task, which is to provide the parties with a fair and balanced forum for litigating matters that are painful and personal to the parties. Terrible time and docket management. Within the criminal legal community, Judge Rainville's mood and lack of consistency are regularly discussed. Litigants do not feel heard. He does not inspire confidence in the judiciary. I do not make these statements lightly. I have never given such a review before. Judge Rainville is unprofessional, constantly sets bail without legal justification, is disrespectful to parties, biased towards anyone with criminal records, misrepresents the laws regularly, jokes with people charged in front of victims and their families, also belittles people who are charged. And what you've just demonstrated here in this room is a complete lack of self-reflection. So you've been a judge for 17 years. You've been through this process before. And yet I see no self-reflection from you. I see no ability to listen and answer questions. And I see a disrespect for members of this committee. So,
Can I ask you a question?
sure.
So if you look at the staff's reviews of me, the side judges who work with me, the people in the courtroom, the staff people themselves, there was 100% support from those folks. 3 different counties, juvenile judges, juvenile staff, family staff, criminal staff. There wasn't a single criticism amongst them. And they watch us every day. So certainly there are things I need to work on. It would be helpful if there was context with some of the comments. There isn't. Just like there were some glowing comments, there were some really strong comments that were supportive. I would not expect you to accept those glowing comments without cooperation. This is a difficult process for you folks and for us, and so I understand its limitations, but I just would ask you to consider that. That's all.
Absolutely. There were some comments, there were good comments. I have no doubt that you're competent in your interpretation of the law, that you're obviously a hard worker. You obviously love your job. I have a lot of respect for that. You obviously want to, get through the cases, and I'm sure that's one of the reasons why the staff likes you, is because you get things done. And I absolutely appreciate that. But I feel like with the comments that I see here, what I would have expected from you is to have some self-reflection, that gives me pause, that makes me think, oh, I'm concerned about how I'm viewed in the court. And when my colleague was trying to discuss this with you, you were flippant and dismissive of her efforts and interrupted her while she was talking. So you just demonstrated in front of me exactly what these comments say. So it doesn't give me a lot of confidence that you're going to improve, that you're going to be self-reflective, that anything is going to change. And you and I might disagree on how you decide a case or what your judicial philosophy is. I heard you say some things that I absolutely disagree with. But that's not why we're here. Why we're here is to assess whether or not you're the kind of judge that we should have in the Vermont judiciary. Whether you treat Vermonters with respect when they come into your courtroom, whether you treat other attorneys and staff with respect, whether you do the job to bring justice to Vermonters in a way that makes our state proud. And what I've read and what I've seen doesn't give me confidence that you're able to do that. And your 17 years on the bench is plenty of time for you to have figured that out.
Thank you, Senator Hardy. Representative Triano.
Thank you. Judge, I have to say that I share some of the concerns we just heard. There are no fewer than 3 and maybe 4 comments that indicate that you are disrespectful to litigants, that you prejudge. And I think the piece that you went off on conditions of release was a little over the top. You know, I understand your position. I don't even argue it in some cases, but to just pour it out on us may have been not the right approach. You know, I saw that you didn't listen totally to Representative Arsenault when she was asking you questions. That speaks loudly to me as well. I mean, I thought you should have listened, sat there and listened, Judge, because that's what we're here to do. I mean, that's what we're here for. You know, some of your ratings, we don't pay a lot of attention to them, but you know, 28% of those surveyed thought that you demonstrate your demonstration of your knowledge of substantive law. 28% rated poor to fair. So some of the highest rating poor to fair. And again, we don't really focus a lot on these, but when numbers like this come up, you start to wonder what's going on in your courtroom, Judge. Again, disrespect to litigants is a recurring theme in some of these. And I'm not going to suggest that all of these comments are negative. We all read them all. We all understand that there are some people that came in forward and said, hey, Judge Rainville's a good guy. I like going before him. But the person who lost sleep thinking they had to go before you the next day is notable. So, you know, it does give me some concern, and I'm not sure that you're getting the message here. I'm not sure that you're hearing what is being spoken of you, even if it's criticism. I mean, the judges that come here, the last 6-8 years I've been doing this, it's like, I get it, I understand. You know, this is what's being said. I get it, I understand, but I'm not hearing that from you, Judge. I'm hearing, well, this is this and this is that. And so it's a concern for me. And I just, like I said before, you know, I believe every person that's appointed to the bench wants to do a good job. And I don't feel differently of you. But what I am saying is that there are some litigants, and you know, your comparison between staff and attorneys. Well, the staff doesn't have to go before you and lose sleep the night before. You know, I mean, that is a big difference. There's a big difference there. You know, your staff can attend to your needs and help you out, and you can have really pleasant interactions with them. But I'm sure, you know, that doesn't really convince us that you have a judicial demeanor that is okay with litigants and attorneys that appear before you. Okay, thank you.
Point taken.
Thank you.
I've already spoken. Any other last words?
Thank you.
And we'll hear from from Judge Kristen Genover.
Kirsten Schoonover. Hello, everyone.
I'm sorry?
Kirsten Schoonover. It's good to see you.
No, I said that's what I said.
Yes, you did. So, hi there. I don't know most of you, so you're new members. I think you've got some new members here, and I recognize you, but most of you I don't know. So, welcome, not welcome, but nice to meet you. And it doesn't lose, it's not lost on me that I am the last judge of I think you've had 13 judges, very last. So that's a dubious distinction. So if it has not been said, thank you for your service. So I am now in the Chittenden unit in the family division doing the family cases, about 1.5 days, do the relief and abuse docket, and then I do primarily the chin docket for abuse and neglect cases. This is my second year of doing that. I've had experience in the criminal division in Chittenden County 2 years ago before I rotated into my current position, and then I was in Washington County doing a criminal family mix as well. So I've basically done mostly family, but a criminal family mix. This is my second retention. I had my first retention fairly quickly, was in 2017. I was appointed in 2015. So just like Judge Driver here, I was a fairly new candidate when I first came here. And this process to the second time, I can tell you, is just very different because the first time is so very overwhelming. It really cannot be said how much work it is, like you, I understand, have to learn to become a legislator. It is like being hit by a 2x4 every day, really the first 6 months. It's just really overwhelming, and you're just trying to do a lot and do it well, because it matters what you're doing. What you matter, you do it every day matters. It's different now. It's more comfortable in the sense that a lot of the judicial making decisions that you have to deal with and address first off, like the first case of first impression, you don't really know how you're going to roll. And with time, you do see patterns in cases. You do see patterns in issues and patterns in families and the issues that may impact those families, and like those patterns come. And as you make those rulings with those patterns, those decisions become a little bit easier. When you see a similar pattern, you say, well, I did this case. How am I going to do it on this case? So it's a little bit less overwhelming. You also learn much more about your docket management system. That really, as a first-time judge, you have no ability to understand how to get through your docket, because really you're just trying to figure out how to do the day-to-day job. That has lessened, and as that kind of overwhelming concerns have been just alleviated with time and experience, then you can open things up for other things. And case management, other things that just have to happen as a judge. I'm the presiding judge right now in the family, so that means any disputes or assigning of cases will come to me. I also run the RFA docket. So with respect to the family docket, that's, as you know, that's not confidential, that's open to the public. Most of my cases in the family docket are pro se, so I have pro se litigants. My time in that docket has really given me, I think, more experience to handle pro ses, because as I become less focused on me and more focused on what's going on before me, you learn with time how to handle pro se litigants to make it comfortable. They have feeling heard. Feel they do have access to justice, that you're not going to make a determination without hearing from both sides. You explain the rules. You explain why you're doing what you're doing. And I've learned sometimes in cases where it's just too painful, child custody cases where one member may be losing custody and there's fighting, it's highly litigious. There's so many emotions. I've learned to stop, make my findings that I need to make, and on the real clearly painful decisions, I will put it under advisement. And I just sit it there, not because I don't know what I'm going to decide. Sometimes I don't, and I need to think about it. But sometimes I do, and I still wait because I know the litigants need the time to process what's going on, understand the judge is thinking about it, and then we'll issue a decision in writing to avoid some of the emotion and drama in court. I've had people so angry they storm out of the courtroom. And I don't need to have that happen. I can control the courtroom better so that doesn't happen. So those are the kind of things that you learn with time. In the Chin's docket, those are confidential. I want to mention one comment that was made, which is controlling the Chin's docket. There was a comment. My first comment was quite a shocker, actually. But the docket in Chittenden County in the Chin's matter is full of really hardworking, well-meaning attorneys. There's no doubt about it. We need more attorneys in this docket, not less. And so I really try to encourage attorneys in this docket because we need it. It's a really important area of law because it really impacts families directly in the most profound way. We're just talking about losing custody of your children. It's a huge docket, and it's families with dysfunction and trauma, substance abuse, and all sorts of issues that come up in family law cases. The bar in this particular county is a dedicated, hardworking, and I want to use the word irascible. They are opinionated. They've done it for a long time. They know how they want to do it, and there's a lot of strife in the courtroom, and that's what I found. I had none of these issues back in Washington County, where I was also the juvenile judge for 2 years. It's very different. Every county has its own culture, and so the culture of this particular docket is it's argumentative. They come in and they argue. So I would say the first 8 months of my time in the docket was crisis management, in the sense that I was getting a lot of complaints by attorneys not feeling safe, complaints by guardian ad litems not feeling safe, complaints that the courtroom didn't feel safe. It was safety all the way around. And so I have bench bars every month, and we talked about civility for a long time to try to get this docket under control, so that when you walk into the courtroom, it's a safe space. That has gotten better. And it took me a while to figure that out and to figure out how I was going to handle it. I felt like a third grade teacher trying to babysit all these kids who are like kicking at each other. And I'm not a heavy handed judge. I'm not the kind that tells attorneys like this is the way it has to be done, because as a matter of professional courtesy, you do your job, and I expect you to do your job. But I have become much more tailored as to how I handle that particular docket, to make sure that you only speak when they ask you to speak, that we don't interrupt people. But I tell you what we're going to do. I'm going to speak, and this is what I want to be hearing on. And on this issue, I'd like to hear response. And then I go right around the room. So because we're often analytic, so people know who is speaking, and it identifies on the record who's speaking, but also minimizes people interrupting each other. So that has been a bit of a learning curve, dealing with this docket. I think it's gotten better, and I think it's gotten to be a more safe space for people. There was another comment about not giving fathers equal shakes, essentially, that's what they said. I'm not sure where that comes from, but I have an idea where it comes from. And that is the situation in Chin's case where we have the custodial parent who, as a way of an example, just say mom was a custodial parent. Mom has a problem, maybe it's drugs, maybe it's mental health, whatever the problem is, but she's got to go to a hospital or a treatment center. And the father comes in and says, well, I want custody. And then the court has to make a determination of placement. That's right out of the gate. Right out of the gate, when you look at these cases, you've got to figure out the placement of these children. One of the cases that I can recall, I placed the child with grandma because the child had a relationship with grandma. Mom and grandma were close and lived close together. The child could stay in the same daycare, same community, close to the grandma who was home when mom's off getting treatment. Dad had come in from another state and said, well, I want custody. It's not my problem. I don't have the problem. I'm not going to treatment. I'm doing fine. I want custody of the child. And I said, no, I wasn't going to do that. So I'm going to do a conditional custody order to the grandma while mom's in treatment, but let's talk about your parent-child contact to get you up here. The attorney disagreed with that, and I can understand why the attorney would disagree with that. And those are some of the hard cases we have. How do you handle that? We've got a dad who was willing and able, but had very little contact with this particular child. And do you take the room with this child who's just lost their mom to go to treatment and move them to a different state to be with a dad where they have some familiarity, but not a lot? And so my step is always, let's go slow about it. I'm glad you're interested. We absolutely want parents to be interested. It is better for the child to have two invested parents. But if this child doesn't have connection with the father, let's take it slow so there's less trauma to the child. So that's just how I see it. You could get two different judges with two different outcomes on that, and that's just true. But that's how I've been dealing with those cases. And I think that's probably where that comment comes from. Otherwise, I'm not sure where it would come from. But I did want to address that. So I'm happy to answer any questions you have.
Brief.
It was brief, yes.
Thank you. Senator Powell.
I think I'm all set.
Representative Austin.
I too have some questions.
I do have to know, I've been doing this for a few years now. And this comment, I only support her retention because Governor Scott has demonstrated an ability to choose even poor and less experienced judges than this judge. It is the best backhanded compliment I've ever read.
You do.
And then moving on from that, I did have one question. So, you commented on briefly the per se clients and whatnot, and obviously the care that they require to feel that they're heard. But do you have any sort of thought or estimate, like how much time does that add to the court process when you're sort of giving a step-by-step explanation throughout the process
It
itself?
certainly adds to it, but I've learned a little bit with time. I check my calendar, I check my clock. So if I have an hour, and most motions are for an hour, I'm giving, so I've already given folks roughly 25 minutes, maybe 30 for the first, 20 for the remainder. I just build it in. I think the only time there's an issue, then I was just talking to Bob about this, is in the RFA docket. So to answer your question, I build that into it. So yes, does it have an impact? But not much. You can quite quickly build it into how you run that courtroom. And sometimes I just limit the testimony, or I may direct the testimony to get the information I need. The only time, and that's why these retention processes are helpful, the only time that I think where I could do a better job is I will tell RFA litigants, I just have a spiel, because I do a lot of them. And I'm like, I'm going to hear both of you before I issue a decision. And then sometimes the plaintiff puts on their case and they actually haven't met the burden. And I already know they haven't met the burden. I'm not going to grant this thing because they haven't met the burden. And then I'll go to a defendant and say, well, I don't actually need to hear from you because they haven't met the burden. I just set that defendant up for failure because I told them that I would hear from both of them if before I issued a decision. I think now I'll change, and so they don't get hurt. And they don't need to be heard because I'm not going to grant it anyway, but they don't know that. I've already told them I would. So I will change my spiel a little bit to say, I'll hear from both of you if I need to hear further testimony. So I may modify that, but that's really the only time where I think I could tweak things a little bit.
Thank you. I'm all set.
So what challenges in the judiciary, logistically, operationally, do you find the most difficult in your day-to-day operation, and what can we do to help?
That's a great question. We are tied to laptops. Okay, our laptops have our own system on them. I couldn't just go over to Judge Rainville and use this laptop and expect it to work for me. You drop that laptop before the case starts because you just dropped a laptop because it's a laptop. So we're clicking it out, clicking it in. You're doomed. Okay? You're just doomed. I know they're working on that to try to get a more centralized system. So that's one issue. We need more support in the courtroom, and I think that's also being worked on. But I have issues with Odyssey all the time. I have issues all the time. I have some issues on Odyssey I've had for months, but we don't have experience. We need people who are experienced with Odyssey in the courtroom and available to the judges at all times. And we don't really have that, and not all courtrooms have that. That would be an enormous benefit. When the system goes down for Odyssey, if that system ever gets compromised, all of our files are in Odyssey. If that system goes down, we have no ability to do anything. We have no paper file backup. That system gets compromised, we've just lost all of our files. Those things I worry about.
Thank you.
I've been wanting to ask this, and since you're the last person, I'll ask you. There are many folks in our country, I would say, who want to reform the criminal justice system. And I was wondering if there's one thing that you could point to that could have huge impact on the system, sort of a structural, systemic piece.
I'm not in the criminal system lately, but I strongly believe in the reparative system, and I think we're moving that way. I think the treatment courts are absolutely essential because most of the cases involving criminal defendants related to substance abuse, whether alcohol or drugs, we have to have good treatment courts in place because we've got people who may have 6, 7, 8, 9, 12 burglaries because they're going in burglarizing houses to feed their habit. So I would love to see treatment courts in all of the courts in the counties, in the state.
Thank you. It's nice to meet you. Thank you for your perseverance, being our last judge. Well, first one comment, this came up in your application and several others, was about broadband. And you were addressing this in your comment, Senator Collmore. And we have put several $100 million into broadband, and more is coming. So I'm hoping that we see improvements over the next few years. So I think that the legislature heard this loud and clear, and we've spent a lot of time on it. So maybe that will get better and make things a little easier for you all. I appreciated your comments about non-native speakers and new Americans, and this came up earlier, and wanted to make sure you'd seen the report that the Office of Racial Justice just issued about accessing government for non-English speakers. If you haven't seen it, you should definitely take a look at that. I also was interested in your use of bench bar and appreciated that you mentioned that. I was going to ask you about it. But what I really want to ask you about is the Newton case.
Oh, my.
Yes, I'm from Addison County.
Okay.
And I'm the chair of the Senate Government Operations Committee, and we are actually working on a bill about sheriffs. And this case, I found it interesting, definitely interesting, about the difference between emergency, an ERPO and an RFA. And I'm blanking on what ERPO stands for.
Extreme risk protection.
Thank you. There we go. And I have to say I was not a fan of your decision in this case, and largely because of the impact it had on my community. And I didn't see anywhere in here any consideration of the fact that this person was a sheriff and therefore held a sort of different role among the community. And when the ERPO was vacated and the RFA denied, there was a sense of fear in the community. And I and others got a lot of calls from people saying, what can we do? this person is a law enforcement officer, has a gun, is unstable. And literally there was a nonprofit organization in my community that had to have extra security put in because of the fear they felt from him. So I guess I'd like to hear you talk about this case and also address the fact that this wasn't just an average person. It was somebody who was a law enforcement officer in our community and the impact that had.
So you are raising a case that illustrates why it is so difficult to be a judge.
Yeah.
Okay? Because if I had denied it, which I did, and he went out and killed somebody, that would be on my shoulders. So that's what it is to be a judge. But the statute is clear for an ERPO. It's got to be clear and convincing evidence. And I had a lot of evidence about him as a father, about his suicide ideation a year earlier. It had been like a year prior to this. So the only suicide, so it's going to be a threat to yourself or others, extreme risk of harm to self or others. There was no evidence of harm to others. So the concern about safety for the wife, there was statements that he had a video that was posted that I listened to. I listened to like 3 or 4 times with the side judge because I'm like, what do you think? What do you think? And there was one comment. There was only one comment that I could get at that I actually thought could maybe be presented as a risk that he had disclosed in this video, and it is not enough by clear and convincing evidence. You may have had it on a preponderance of the evidence standard, but not clear and convincing. So if you want to change that, change the standard. Because how could...
The standard for ERPOs or the standards for RFAs?
For ERPOs are clear and convincing. It is preponderance of the evidence on an RFA.
Yeah.
So you've got to prove to me by clear and convincing evidence that he was a risk of harm that wasn't to himself, because the suicide gesture was a year earlier. Like, how is that an immediate danger? It's not immediate because a year earlier. Mm-hmm. And in the meantime, he had gotten therapy, and he talked about his therapist. And there was very little evidence of harm to others other than this kind of rambling, clearly unwell, not so great. There was no evidence of use of a firearm, that he was using his position as the sheriff to intimidate. No evidence on that.
I thought there was, because the whole circumstances surrounding it was him using his office as intimidation to this woman.
I don't know if that's true. I think I'm not in Madison County, and I walked into this pretty fresh because I didn't have any expectations because I didn't know Peter Newton.
Were you sitting? Oh, it was moved to another county.
They changed venues. I wasn't aware of there was a digger store that had come out about him, and then he had responded to it. I was not aware of that when I walked into this hearing, and so I am bound by what is presented before me. And I tell you, I had this before with prosecutors. I have cases where I dismiss because there's not enough evidence. I may not find a merit for a Chin's case where I have concerns about the kids. And I'm like, I really wish they present this evidence because I don't have enough.
Right. I feel like there was evidence, and it certainly there was evidence in our community about the fear. I believe it. I saved all these messages, but I got so many calls and concerns, and our entire delegation and the governor called for his resignation, and he refused. But on part of it, you say the question for the court is whether convincing evidence that he presents an extreme risk of harm to himself. Now the court does not find so. The statute does not define what constitutes an extreme risk. Do you think it would be helpful if the statute did define extreme risk?
It's always helpful to have terms defined.
So defining extreme risk, and then also clear and convincing evidence versus preponderance of evidence. Yep. Preponderance is the lower standard. Okay. I found this case really interesting to read. I was like, oh, was this a little gift for me that she put this in here? And that's fascinating that it's about the evidence that's presented to you, because it seems to me that in this case, there should have been you knew he was a sheriff.
Of course, that was definitely part of the case.
Yeah. And that there should have been a higher standard held for someone who's a law enforcement officer.
That could very well be. And maybe I could read that into the statute. I mean, the statute doesn't say that. But if I had found extreme risk of harm to self on a suicide gesture a year earlier, that would open the door to anyone who's tried to commit suicide and has gotten help. There was no evidence that this man had since then made any sort of harm to self. So we get off that prong, and now we're looking at harm to others.
Right.
And the question is, was he threatening his wife? There was no threats to his wife, no direct threat. He was rambling. He was scary. And I purposely put in that decision. I don't blame the state for filing this, and I don't blame the wife for filing it either under an RFA. I don't blame you. But I deny cases all the time. They can't meet the burden. And does that mean I felt good about this decision? No. But if I want to open the door and squeeze a little bit on this one, when the suicide risk was a year ago, well, I've just opened the floodgates.
What my concern was, I mean, yeah, it would have been tragic if he committed suicide, but my concern was the safety of the community. And it didn't seem like that was taken into consideration.
Because there was no evidence of it. There was no, other than, I suppose you can make an argument that a sheriff who is having mental health problems isn't of itself harm to the community.
Exactly.
But is it extreme risk of harm? And how would I find harm to the community? I can find harm to the wife. I can find harm to self. There is no harm to community standard. There is no public safety. The public safety, I mean, it's all about public safety. It's harm to himself or harm to others. And I was looking at the wife, harm to the wife, but there was no threats made to the wife, not directly.
Mm-hmm.
It was there. It was vague. It was subtle. I mean, it was certainly threatening.
Mm-hmm.
But I couldn't find abuse. This is RFA statute now. I couldn't find abuse. The abuse statute, and I know you've got a bill coming up about the abuse statute. Abuse is not defined that way. Mm-hmm. That would not cover under abuse under the RFA statute at all. So that's not even close. So that's that. So the abuse is, I knocked that one out in Title 15. But under the IRPO, I have to find extreme risk of it. I just didn't find it. Mm-hmm. And I agree with you. It was a troubling statement, and I didn't feel great about it. But that's the hard part, because he could have come out and hurt somebody.
Yeah. Well, he certainly caused a lot of hurt in the community and a lot of fear. Yeah. And now there's a bill to deal with sheriffs because of he and others. I guess, well, so sorry to take up so much time on that because that was just of personal interest to me. What do you as a judge, given what you've seen in the comments and the ratings for you, feel like you need to work on for the next phase in your career?
Not based on the comments, but I would like to get really kind of focus on children's resources, because I see this in the CHINS case. We have just such a lack of resources that I've almost dismissed cases in the CHINS docket, because I'm like, if we're going to file a CHINS case, not we, the state's going to file a CHINS case, and I'm going to order DCF custody, and we place this kid in custody, and we have no place for them, because there's patterns of kids, there's just no place for them. There just isn't. So I'm like, what are we doing? So I would like to focus on that, to see resources for these kids. So the state's going to actually take the step of filing a CHINS petition, and I'm going to actually place a kid in DCF custody. We're going to actually get a good result at the end of it. And I'm not always certain that that is true. Mm-hmm. I think we try, but we don't have enough resources. That would be an area. And then, just making it so the courtroom's accessible to all. Then there's a fine line between access to justice and making sure people are heard, and then towing a line and making sure you control your courtroom. That's always a struggle. And sometimes they're just hard to balance. And I think just with time, experience, I'll get better and better at that. Yeah.
Thank you.
Thank you, Judge. What you have just said reminds me of on Corrections and Institutions Committee here in the House, we're trying to recite Woodside, mm-hmm. which is likely to be a 5-year project between citing it and planning it. And so it's troubling that we do not have a place mm-hmm. that can accommodate troubled youth, mm-hmm. Especially teenagers. And if you'd ever been to Woodside, you would have.
I have been to Woodside, yeah.
Really understand that that should have been closed down. There is the new facility in Essex. We're hoping that will accommodate some. We're finding that softer approach, less locking steel doors and softer furniture and better accommodations will help in this situation and re-entering into the community. So, I just wanted to let you know, I mean, we're trying on that, but boy, it's a heavy lift.
Yeah, it is a heavy lift, and that doesn't even account for the 19 and 20-year-olds, the youthful offender.
Yeah, well, they will be coming into it, I think, at some point. But I also just want a comment. I don't disagree with your decision on what Senator Hardy was just discussing, but we're taking up a suicide prevention bill in the House also, and we're finding that 80% of male suicides are by firearm, and the remaining are less likely to actually be fatal and less likely to reoccur. So that portion of our population that are surviving an attempt are not actually committing suicide. Just some interesting statistics that we came across. And of course, special to me are veteran suicides, which we all know are at a high number.
Yeah, it's tragic.
Thanks for coming. That's all I have.
One comment on the conditions of release. There was Justice Carroll had done an article, I think in the Vermont Digger, maybe in the last 2 years. It talks just about the issue that you were raising for.
Oh, thank you.
Yeah, so look for it. It's out.
I will.
It does explain it just as Justin. Thank you all. Appreciate it.
No,
Oh, I'm sorry.
the comment about you being on call for relief from abuse orders and refusing to take the phone call.
So
Your side of that?
So by side of that, I don't know what they're referring to. In terms of, I would never, if I'm on call, I would never refuse a call. Period.
So what you say is it simply never happened?
I would never refuse a call if I were on call. What sometimes happens is we cover each other's calls all the time because you just miss them if you're on call. One of the issues we were having is, and I think it's been addressed, is I was on call and I missed the phone call. And then I called back the officer because it's like 3:00 in the morning. And I don't want that officer waking anybody else up because it's 3:00 in the morning and I'm on call. That does not make you popular with the colleagues. So I would call the officer to say, I'm here. Like I fumble with the phone. And then what was happening is the officers were calling from the station. They weren't calling from the personal cell phones. So when you call the station, it doesn't accept your calls. So the officer would call you. I fumble the phone. I can't pick it up in time. I call back and I can't get through. So we have come up with a process that say, call at least twice and give us a number so that when we call back, we can actually get to you. So that has addressed those concerns. But even so, there are certainly times where, the judges, like I missed a call because I was off for a run. I didn't have my phone with me and another judge took the call. That happens all the time. The only time I've ever had an experience that closely mirrors that comment was when I was on call, and it wasn't a relief from abuse. It was a search warrant, and it was at 4:30 in the morning, and it was my fourth call, and it was Monday night, and I was tired, and I was pretty grumpy too. And I said to the state's attorney, I'm like, it's 4:30. Can't you wait till 8:00 in the morning? And I meant it. Like, can't you wait till 8:00? Because that's my fourth call. I pulled an all-nighter on a work night. And the state's attorney at least said, I don't want my cops waiting around for the next 4.5 hours, which I understand. So I did the search warrant. But so that's the closest I can as to an experience where I actually was pretty grumpy about it, but I would never deny a call. And I can tell you sometimes, and I'm not saying this is the answer, but our on-call system is not a tight system. Sometimes we're on call, this clerk send out the rotation schedule to the police, and they just don't have it, or they're just not using the right one. So it's not as clean a system as perhaps you would like, but no, I would never reject a call if I was on call. Okay.
Thank you.
Thank you all.
Thank you.
Appreciate it.
Thank you all. As a legislative committee, we are subject to the open meeting law. We operate in public, but judicial retention does involve essentially personnel. It's a personnel matter. And I think we should go into executive session that which we can do and should do for a personnel matter, that requires a 2/3 vote of the committee. Would someone like to make a motion?
Chair McCormick, I would move that the Joint Committee on judicial retention, go into executive session.
I'll second.
And that is to consider the evaluation of a public officer, particularly the retention of the judges up for retention.
Yes, that's what it would be.
Okay, you've heard the motion. No, it has been seconded. All those, is there any discussion? Hearing none, all those in favor?
Aye.
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 It appears unanimous and the chair votes yes. I need counsel. Do we have to go back into open session after the executive session?
Yes,
Okay.
to formally.
To restore formal
action.
Okay, so we have to kick everybody out.
So we're going off lockdown. We're going off.
We're going